Thank you, Mr. Chairman. First, let me state to the Attorney General that I share your commitment to trying suspected terrorists in our Article 3 courts, and I applaud and congratulate you and the Department on the successful prosecution of Osama bin Laden's son-in-law, Sulaiman Abu Ghraib, I think his pronunciation is. That conviction came 13 months after his arrest, and he now faces a potential life in prison. By contrast, Khalid Sheikh Mohammed and his four co-defendants have been in custody for more than a decade, and it remains uncertain when, if ever, the military commission system will finally be able to get around to a trial. I hope with the conviction of Abu Ghraib that we can stop wasting time and money on a so far unsuccessful military tribunal system and secure the convictions of the guilty terrorists in our Article 3 courts. And I want to thank you again for restating today your commitment to that system. Now, following the failure of many savings and loan institutions in the late 1980s, special government task forces referred 1,100 cases to prosecutors, resulting in more than 800 bank officials going to jail. By stark contrast, no senior executive at any large financial institution at the heart of the 2008 financial crisis has been charged or prosecuted. Just last month, the DOJ Inspector General concluded that the FBI ranked financial crime as its lowest criminal threat in the aftermath of the 2008 financial crisis, did not use some of the additional funding that Congress provided to pursue mortgage fraud for this purpose, and that DOJ mistakenly inflated its results in mortgage fraud prosecutions by some 90%. That report is very troubling. My question is, why didn't the DOJ or the FBI devote the same kind of resources that were devoted to the savings and loan crisis in the 80s? What steps are you now taking to investigate whether money allocated by Congress to pursue mortgage fraud was misspent? And what other steps are you now taking in response to the IG's report? And finally, in light of this experience, the total failure to prosecute high-ranking or even investigate high-ranking bank officials for the fraud that led to the 2008 crash, what steps are you taking to ensure that the full range of possible criminal charges will be investigated with regard to General Motors and its faulty ignition switches that reportedly have been resulted in at least 13 deaths years after they knew about them?
Well, with regard to the OIG report, I just take great exception to a lot of the conclusions that are contained therein. If you look at the report itself, the number of mortgage fraud convictions nearly doubled from fiscal year 29 to 2010, from 555 to 1,087, and then increased further in fiscal year 2011 to 1,118. And this, I think, reflects a really rapid mobilization on the part of the department to combat mortgage fraud during this critical period. If you look at, as I said, some of the results that we've had over the past year and a half or so, including that $13 billion resolution with J.P. Morgan, that makes clear, I think, our determination to hold people accountable. We had the national mortgage settlement resulted in $20 billion in relief and assistance going to more than 600,000 families. And if you look at more generally our history of holding accountable institutions and individuals who are connected to this financial fraud, beginning in 2013, we have gotten guilty pleas from the following financial industry institutions: UBS, RBS, SAC Capital, Wegland. With respect to prosecutions of individuals, we have charged individuals from the following companies: J.P. Morgan, Goldman Sachs, Morgan Stanley, Credit Suisse, UBS, Rabobank, ICAP, Galleon, SAC Capital, Stanford Financial Group, Allen. So the notion that somehow or other we are not been doing what we should have been doing with regard to the mortgage fraud problem, the financial industry in general, is a nice talking point, and I don't mean to say that's what you're saying, but it is used by some as a talking point. It seems to be inconsistent with the facts.
Well, thank you, but it is essentially what I'm saying. I think going after a company which can pay a fine paid by the shareholders is not the same as prosecuting someone other than small fry, is prosecuting the higher-ups in these companies who okayed this. But let me get on to my next question. The review group appointed by the President to review the Section 215 bulk collection of telephone metadata concluded, among other things, that a single legal standard should apply to NSLs and Section 215, because otherwise you simply switch from one to the other. Do you agree, and I hope you can be brief on this because I have one more question, do you agree that we should follow this recommendation, that we should make the same standards for NSLs as for 215?
Well, I think that, we have to understand that the different nature of these. NSLs were a tool to obtain really narrowly defined types of records from a narrow set of institutions. By contrast, 215 allows the government to obtain any tangible things. And because 215 has a much wider breadth of materials that can be obtained, the need for judicial supervision, I think, is more obvious. NSLs, you get information that are used to build cases in the same way that you use grand jury subpoenas that, frankly, do not involve judicial supervision.
So you don't agree? So you don't agree with the recommendation of the President's Review Commission?
I've stated my position, yes.
Okay. My last question is, the President, when he campaigned back in 2008, said he was going to rein in the state secrets, the use of the state secrets doctrine. And he has mildly done that by saying only higher-ups in the department can approve it, and they'll use it more sparingly. But you still use the state secrets doctrine to object to a case, as an answer to a complaint, and completely stop a case from being heard. And this means that people cannot get their cases into court, that rights cannot be vindicated, that the judicial system cannot even consider many allegations. A Ninth Circuit panel said that the problem with this was that the executive cannot be its own judge, and under this system, the executive is its own judge. I would observe that this insulates the executive from any accountability for its actions, because it can make classified some of its own actions, and then block any judicial review by incantation of the magic word state secret. Do you think that it is proper or wise in a democracy to entrust the executive branch with such absolutely unreviewable power over our liberties in such a way that rights can be violated and no one can get into court to challenge those rights?
Time of the gentleman has expired. The Attorney General will be permitted to answer the question.
Well, we've really fundamentally changed the whole invocation of the state secrets privilege. I put in place a series of measures so that that determination can only be made after review by a high-level committee and ultimately by sign-off by the Deputy Attorney General and by myself, understanding that we were never to use the state secrets privilege to hide things that were embarrassing or to hide government misconduct. There is a reality we have to also face, though, that there are certain cases that bring into or potentially bring into the public realm things that would harm the national security. I'd also note that in a different, maybe I'm not sure what opinion you're referring to, but I know in another opinion, a Ninth Circuit judge or a district court judge in the Ninth Circuit noted very approvingly of the changes that we had made in the Justice Department with regard to how we deal with the whole question of the invocation of the state secrets privilege. And I'm actually proud of the work that we have done. I think that we can justify every time that we have used it, and it has been used extremely sparingly by this administration.